Another major issue for Native Americans in Oklahoma and the rest of the country right now is the Indian Child Welfare Act. It governs the removal of Native American children from their home and where they are subsequently placed in an effort to keep them with other family members and with their tribes. But as Stephanie Sy reports, next week the U.S. Supreme Court will hear a challenge to the law that could dismantle it entirely.
7-year-old Willel, which means hummingbird in Cherokee, is learning the language of his tribe. At this indigenous language immersion school, all of Willel's subjects are taught in Cherokee, and the children learn to write in the syllabary created by Sequoia. Willel's great-uncle, Curtis Washington, is one of the teachers and one of a dwindling number of native Cherokee speakers. Were it not for the Indian Child Welfare Act, or ICWA, Willel might never have uttered a Cherokee word. When he was only 23 months old, authorities removed him from his biological parents due to child endangerment.
So we prayed about it, and we just thought, that the Lord put him in our hands, or we wouldn't have gotten this call.
The Cherokee Nation's ICWA office invoked the law to prioritize finding suitable guardians within his extended family, which ended up being his great aunt and uncle.
What would have happened if you had not taken him that day?
DHS told me that they would have been put in a foster home. If it went to a non-Cherokee person, they wouldn't have any idea of anything, of how a Cherokee lives, any of the culture.
Before ICWA, Native children in Willel's situation would routinely be placed with non-Native families, severing them from their tribal heritage.
They were moved completely out of tribal lands, completely out of tribal families. This was devastating for tribes.
The chief of the Cherokee Nation, Chuck Hoskin Jr., says when Congress passed ICWA in 1978, it was to rectify that gross offense.
Now we're looking at a generation in which I see young people out there striving for excellence. I see our language being revitalized. I see renewed interest in our culture and our history by our own people.
45-year-old Julie Skinner, who works for the Cherokee Nation, is among the first generation to benefit from ICWA's reforms. A member of the Ponca tribe in Oklahoma, she and her twin sister were removed as babies from their biological parents, who weren't able to care for them. Before they turned 1, they were moved among 20 foster homes.
I had a lot of fear. That's my first memory, is fear, and being afraid of not really remembering what I was afraid of, but of everything pretty much.
Because of ICWA, they were eventually adopted by a paternal relative.
Do you ever think about what your life would have been like if you had been severed from your tribal family?
That would be a huge loss for me that I don't think I could have got over. I know I would not be here where I am right now. I think I would have probably be lost.
The systematic repression of Native language and culture throughout American history, from forced relocations to forced family separations, is a key argument proponents cite for keeping the law.
But ICWA has always had detractors, and on November 9th, the Supreme Court will weigh in the case of Brackeen versus Holland. Plaintiffs opposing ICWA allege that the law violates the Constitution's Equal Protection Clause and the anti-commandeering doctrine, which states that the federal government cannot require states to adopt or enforce federal law.
ICWA is itself systematic racism against children who are at the greatest risk of any demographic in the country.
Timothy Sandifer of the Goldwater Institute says Native American children are being deprived of legal protections based on their race.
It certainly is true that ICWA had good intentions and it was passed. Unfortunately, as often happens, Congress went way too far in the other direction and said that the best interests of a particular child should take a back seat to the desires of tribal governments.
He points to cases where he says the application of ICWA has harmed children because it puts a different standard on removal from biological parents.
It should be, as with all other children, a case-by-case determination where the most important thing is the child's best interests. Instead, by making it prohibitively difficult to sever the rights of an abusive parent, ICWA ends up harming these children.
The best interests of the child are also what worry Michelle and Robert Guerrero, who live outside of Sacramento, California. Like the couple we met on the Cherokee Nation, they have been raising a little boy, Robert's grandson.
He was released to us at 8 days old, and he's been with us ever since.
And why was he released to you?
The parents were both addicted to drugs. We'll do an 8.
We are not identifying the 5-year-old boy because of the ongoing legal process the Guerreros are now entangled in. The boy's father, who is Native American and now sober, decided in March to petition for custody. The boy is not an enrolled member of the tribe, but ICWA is being applied to his case.
I think we feel the decision was made before even getting to court because that they are a Native American family, not giving any thought to the family that he has here.
When he's not playing grocery store or with his toy trucks or barbecuing with Robert, who he calls Papa, the Guerreros have tried to connect him with his Native heritage.
They sent an ICWA specialist here to talk with us, and so we talked about Native American stories and Native American music. We have the Maidu Museum here in the area. We used to take him there, campfire night. We'd invite the biological father to come as well. So it's definitely something that we want him to experience and be a part of.
But the Guerreros say stability is the most important factor at his tender age.
The best interest we felt was for him to stay where he is and continue living in the home that he's known for all his life.
They're watching what the Supreme Court does on ICWA closely, as is Julie Skinner, back on the Cherokee Nation.
If the Indian Child Welfare Act is overturned, we'll be devastated. This law protects that voice for tribes because we've been silenced for so long, and to have it silenced again because people from outside our tribe think they know better than we do is heartbreaking.
Cherokee Chief Hoskins says the stakes go beyond the placement of tribal children. If the Supreme Court dismantles ICWA, it could affect other federal Indian policies and tribal sovereignty.
I think it'll set back the progress we've made in Indian country, and I think it fundamentally changes what it means to be a Native American in this country, and we really can't let that happen.
For Curtis and Jeanette Washington, Willel was a blessing in disguise. Raising him has reignited their own connection to their Cherokee identity.
Cherokees need to stay in the Cherokee, culture somehow, some way.
For the PBS NewsHour, I'm Stephanie Sy on the Cherokee Nation in Tahlequah, Oklahoma.